Thank you everybody for joining us. John, thank you very much for joining us from CDH. John is here this afternoon to explore with us the potential legal impact of COVID-19 on private equity fund terms. I know it's very relevant for most of you who are joining us here today. So we're very thankful for CDH joining us here today to take us through their thoughts on the impact. John, thank you for joining us. I'm going to hand it over to you. Good luck.
Thank you, Melanie, and I hope everyone is healthy and happy and safe at home. I wish you and your families all the best during this very challenging time. This has been a challenge. I was thinking about preparing this talk. We've gone through a number of crises. I still remember my first job as a budding article clerk in the late 90s was another type of virus or bug. And that was that we all thought the world was going to come to an end on the 1st of January, the Y2K bug. And I remember reviewing lease agreements that had been drafted in the 1913, 1914, before the First World War, that were written in High Dutch, and I had to take them to the University of Natal and have them translated to see how the force majeure clause would work in the context of a terminal or Durban harbour, where they hadn't quite in 1913 thought about the consequences of that crisis, which turned out to be a non-crisis. But that was my first sort of experience in a crisis of sorts. We then had, shortly thereafter, the dot-com bubble burst. We then had 9/11. More recently, we've obviously had the global financial crisis. And all of these have been different crises with different kind of challenges. And certainly this COVID-19 one is a real crisis. I don't think we've ever experienced anything like this, certainly in our living memories. And it's posing a number of unique and interesting challenges. And so the purpose of this really talk was to explore with you, and really I welcome any questions, suggestions and thoughts that you have around what we as practitioners in the private equity space should be thinking about and doing to mitigate risks and directly address the challenges that we're confronted with. So I've tried to divide the talk into various parts and looking at, because I think that the challenges are different to the different stages of which your fund might be in. So if you're at a capital raise phase versus if you're at an investment period, if you're in a holding period, sort of that bit in the middle, or are you towards the end of your fund life cycle, then I want to sort of go into the general considerations, things like force majeure clauses, what should you be taking account of, and then just regulatory considerations. So as I said, you know, this COVID-19 pandemic is really posing some unique challenges. In some ways, I think private equity fund managers aren't challenged in the same way as, for example, CIS managers are, where they're facing massive disinvestments of funds or moving of their investors. In the private equity context, investors tend to be locked in for the time being. But that doesn't mean managers shouldn't be doing anything right now. I think they absolutely should. I mean, I think their focus should squarely be on if the fund is up and running, for example, on their portfolio entities, and what risk mitigation actions they should be taking as soon as possible. But I also think one needs to be thinking ahead at the same time. I don't intend in this talk, and I think it would be impossible to give you what I think all the outcomes are going to be, because I don't think anyone knows. And I think if they say they know, they're lying. Because we don't know how this is all going to end at this stage. But I do think we should be looking at our fund documentation and certainly, and I'll take you through it, through the various phases, what you should be thinking about in the back of your mind and what actions you should be taking. So, you know, maybe if we can first turn, Melanie, to the next slide, looking at funds that are currently raising capital. So I'm talking about here where you might not have hit first close, or you've hit first close, but you haven't hit final close. I mean, obviously, this is going to have, this COVID event is going to have a significant impact on you. you're not going to be able to use the traditional road shows. You're not going to be able to get on planes and travel around the world and see investors and market your fund. So I think if you're in that space, firstly, I would focus on the investors you perhaps have an existing relationship with, ones who've done advanced due diligence on you. And then think about, I think we're all moving, and one of the effects of COVID, I think, is technology and the use of technology and working from home and using things like Zoom and webinars and reaching out to clients that way, because that's where we kind of, it's all we're left with at the moment. But the traditional mechanisms are close to us for the time being, and we just need to accept that and find alternatives. To the extent you've reached first close and you haven't reached final close, your documents are pretty set at that point in time. And traditionally, you've got about 12 months, possibly 18 months to reach final close. Maybe you've got a small ability to have a 6-month extension in there. But it may be that you want to speak to your investors now, Evan, and start communicating with them if you're looking to kick that final close date out to give yourself a bit more time to reach your funding targets. I think you're going to find a theme of this discussion is going to be talking to your investors and transparency, because I think that's going to be the secret sauce to getting to a successful outcome. And certainly that was my experience during the GFC, is that those managers that engaged meaningfully with investors, often their relationships got strengthened, quite frankly, going through the crisis together. So that certainly will be a theme that will come through in the talk. I think the last thing, really that you should be looking at if you're in that initial capital raise phase is looking at your PPMs, your offer documents, and the risk disclosures. Are they sufficiently addressing, because these are forward-looking statement documents. So certainly if you haven't reached first close, you should be putting in risk disclosures specifically around COVID. And even if you haven't, you should be looking at, to the extent you are handing out offer documents to subsequent close investors. So that's certainly something that I'll be looking at right now if I were you. Melody, can we move on to the next section, funds and investment period? Thank you. So again, I'm talking about now you've done this is the time period from first close where you could start making investments to the end of your investment period. So this typically is about a 4 or 5 year period at the outside when you're starting to acquire your portfolio assets. I mean, quite obviously, COVID, well, certainly in a number of sectors, hospitality, retail, I mean, they've literally ground to a complete halt, and that's not just in South Africa, that's globally. So, if one looks at financial statements or if you've got valuations, I mean, they, to a large extent, are going to be meaningless right now, and it's going to be very difficult to assess where you are in the process as far as evaluations are concerned. And to conclude agreements right now is going to be challenging, just on a pure valuation basis. And I'm sure a lot of people are going to be revisiting deals right now. And that with it brings time challenges. And I think importantly, and it's something, I'm slightly digressing here, but I will be uploading a set of notes which broadly follow what we're discussing today. But one of the things I didn't mention in my notes, which I should and I will amend it, is regulatory consents. So we've already, in recent engagements we've had with SAVCA and engagements with the FSCA, as you can imagine, a lot of these regulatory bodies where you often do require consents to close a transaction, and they're hardwired CPs, competition approval would be another one, is they're just not working optimally right now, and you can totally understand that. People are working from home, they can't hold their investment committees. Often these regulatory bodies don't have the ability to do that. Remote, I can certainly have seen that they are gearing up and they are moving in the right direction. And in credit to our regulators, they have been proactive in providing certain exemptions, and I'll get to those at the end of this discussion. It's one of the items. But there will be a slowdown in getting your regulatory consent. So you will have your long stop date of 30 days to obtain approvals A, B, and C may now not be possible. So the question is, what should we be doing? Well, the first thing I think is, to the extent you can, look at again engaging with investors, pushing out that investment period, if that's possible. Certainly if you're running up against it. So if you're in year 3, 4, and you've got one more year and you haven't deployed all your capital, you certainly would want to hold back and see if you can't wait a year until things settle down to make those investment decisions. Another thing is, and this certainly came out in the GFC, was reviewing investment guidelines. You might have a very conservative set of investment guidelines. Again, I'm not suggesting you do anything outside your guidelines which hasn't got the prior approval of your LPACs or your advisory boards. Obviously engage with them, make sure they are on board. But there are opportunities now in the market as well to make deals. And that could be in the debt risk finance space, for example, which isn't the traditional sort of where you're an equity focused fund where you might be looking to normally invest, and there might be really good opportunities right now coming out of this crisis. So that's something certainly I would look at, is whether you can possibly amend mandates. Again, making sure you're worrying about, or you are taking care of conflicts of interest, that you are checking with your investors and making sure that they're also on board. Business plans, really important. Again, often deals or funds are created on the basis of a very defined business plan, or you've done a particular deal based on a particular kind of predetermined business plan, which you've mapped out for the next 3 years. All of that might be completely irrelevant right now. And again, I suggest is, if they are, don't keep quiet about it. I think everyone accepts we are dealing with a unique situation right now. Engage with your investors, draw up new business plans, but engage. I can't overemphasize that. And set out and discuss with your investors what your mitigation strategies are going to be. Drawdowns is an issue, and I know that was a specific question that was asked, one of the attendees asked beforehand, and I just thought I'd address that briefly. So, and I actually had a question from a client recently from the UK this morning, was asking me, are we seeing any defaults on drawdowns? And the short answer is I haven't seen any yet, and I hope not to see any. But do I think there might be? Yes, possibly. There could well be. I mean, these are extraordinary times. How do you mitigate that? If possible, perhaps give your investors more time, speak to them about your drawdown strategy. And if you think there's a real risk of a drawdown, of a default, you might want to engage with the investor directly, or the other investors, see if they want to take up that shortfall. Again, be very, very cautious though in these discussions with investors that you're always treating all your investors fairly. I mean, you can end up tripping over your shoelaces and getting yourself into trouble from a code of conduct perspective, But if you do think someone is going to default, rather than just relying on the default clauses, these are extraordinary times. I mean, you might land up there, but if you could negotiate something that's better, or if it's just a case of timing that people just need because of liquidity constraints, an extra month or two, then try and accommodate if possible. I do think it's a good idea to perhaps, and again, this is going to be very sector specific and sector focused, is you might want to do a short-term drawdown, not short-term, but take a drawdown of some capital, which may be needed to plug holes in your existing portfolio in the form of follow-on investments if you need to preserve those. And we've already seen a couple examples of that happening. I mean, I think there are going to be companies where the balance sheets are going to need to be propped up in order to preserve them. So, absolutely make sure that you're doing that. Meetings of investment committee advisory board. Certainly the fund documents that I've seen recently, they almost all allow for meeting by way of online meetings like we're having right now, or via conference call. But just check your documents. Obviously, if those aren't permitted, then that would be something that I'd be recommending to amend immediately in your documentation, because I guess we're all hoping and praying that come, I think it's the 17th, but no, the 17th we're out of this lockdown. But I have no doubt restrictions will continue, and the lockdown could be extended, or we could have future lockdowns. I mean, as most pandemics, we're going to go through waves of these things. So I'd certainly be planning for that. The last comment I wanted to make under the section was key persons. Just, review your key person provisions. I don't think that's a material risk, in that it seems to be that the length of time people are suffering if they do catch COVID tends to be a pretty short period. We're talking weeks, not months. In the majority of cases, the morbidity rates seem to be, certainly in South Africa, very low, thankfully. So I don't think but have a look at your key person events if that is relevant to your business. It's certainly something to take account of. Melanie, could we move into the next section, funds in the holding period? I've kind of covered the first point in this, and so here I'm talking about you've got to the end of your investment period. You're not quite coming to the end of the fund. You've got that sort of 1 or 2 years in the middle where you're sitting on assets and hopefully growing the assets and improving their values. So what should you be doing in that period right now? I mean, and I think this first point doesn't really matter where you are on the life spectrum of a fund. Looking, what should you be doing with your portfolio assets right now? If they're under stress, should you be capitalizing them further? You should absolutely be checking your funding documents. I'm not a banking or finance lawyer, but I've certainly been exposed to enough to know that they've got a number of financial covenants in them. You might be breaching those covenants, inadvertently getting close to defaults. So those, I would be very, very proactive in that regard. And again, if you need to take steps, if you need to do drawdowns to plug balance sheets, chat to your LPs and take the necessary action sooner than later. I think the secret here is going to be about being proactive as opposed to reactive. So to the extent you can be proactive rather than reactive, be proactive. I think people, investors may forgive you for taking a step that was done in good faith to protect the assets, but they're unlikely to forgive you if you just sat back and done nothing and just let it all melt down. So other things to look at during this period, recycling of commitments. So if you have recently done a sale, or you're in the process of closing a sale, and you've got some distributions, you've got some cash, possibly if you've got recycling provisions, maybe hold back on some of that right now. You never know when you're going to need it. I think I've dealt with the issue of reporting, so we can perhaps, we can move on to the next slide, but I guess the final comment is, government is putting in place a number of bailout packages, for want of a better word. Stay abreast of those. Certainly if your portfolio companies fall within the SME space. I know there was certain tax relief that was given, it was yesterday, it was published, and you can hold back a percentage of the payroll. They might not be applicable, but if it's applicable, make use of it. Again, don't miss an opportunity. Some companies, it might just be that PAYE that you're holding back that gets this company through the next month or so. Some companies are going to be really living on the edge for the time being. So, if you can make use of government incentives, solidarity fund, absolutely do that. Be alive to it, and if you need advice on that, please don't hesitate to contact us. We've got a number of partners who are working and getting their heads around all these different initiatives that government's putting in place. So I thought this was quite an important section, the next section, funds nearing the end of their life cycle. And a lot of this that I'm going to discuss came out of the GFC and what we did during the GFC with private equity funds. And some of this is not from the South African market. So I just want to say that if you say, well, I've actually been in the South African market for a number of years and I've never heard of what you're referring to, John. A lot of this comes from the US and the UK. So we did quite a bit of research looking at what they did at the time of the GFC, and certainly doing some reading online to see, well, what are their advisors saying to fund managers right now. And it seems a lot of the trends are actually holding true. So what was done in the GFC, people are proposing right now to deal with COVID. So you've got a number of options. And what am I talking about here? So you've got to the end of most funds, as you know, 10+2, sort of typical market standards. So you've got a 10-year fund life cycle, then you've got to be done, or with usually two 1-year extensions. But then that's kind of it. That's the end of your fund life. And you could well be running right up against that hard deadline. And so what do you do where you've got some, what potentially was a brilliant asset a month ago, and you've got no idea what it's worth now. And you've also got no idea what people are going to be prepared to pay for it. And so you really could lose a lot of money if you were forced to sell in a kind of fire sale scenario, or doing distributions of dividends and species of shares. I mean, investors and LPs hate that. Often you'll find that in their side letters. So what can you do? So I've set out a few of the options, and I'm just going to go through those in turn. So the simple one, go to your investors and say, can we extend? There'll usually be quite a hard discussion there around fees, because investors are not going to be terribly thrilled about paying management fees going forward. But you can potentially come to an accommodation there, because the argument is, well, we can sell right now, but I can make no promises. I mean, you may not get your capital back. Forget about carry or anything like that. To sell in the current market, it's just it's potentially incredibly challenging for all the reasons that I've already mentioned. So that is a simple fix. Could be, let's kick the can down the road. So let's extend the fund life for a year or two and see if that's a possibility. The second option, co-investments. You could possibly get investors to come in and sort of make follow-on investments into existing structures. So that's something you can do, and you can set up a whole policy framework for that, dealing with fees, carries, expenses, time frames, and the like. So that's another alternative. Another option, secondary transactions. And I've been working on a couple of those anyway right now, because we've been sitting in quite a challenging macroeconomic climate in South Africa pre-COVID. We really didn't need this in South Africa. We were already operating in kind of recessionary conditions. And I've had a couple of funds where they're towards the end of their fund life cycle, and they've tried to extend and they can't really extend, and so now what? So one of the options is to put into place a kind of continuation fund. So you effectively create a new fund, get investors, often existing investors, into that fund, and then you give the investors in your old fund you sell effectively the portfolio across, and you say to them, listen, you can either cash out effectively at NAV or even at a discount to NAV, or you get an interest in the new fund, and then stand a chance of effectively realizing your return as and when the market approves. So all you're really funding then in this new fund is those LPs who want the cash out. So if you had a situation where you had one LP, so you couldn't extend, your fund because that required, for example, unanimous consent. And that was a 10% LP that was blocking effectively a fund extension. One of the ways you could deal with this is to create a kind of a continuation fund where your 90% would go and that roll over effectively, and you'd then cash your minority out. Again, really got to be so careful here of conflicts and issues like that, and making sure you're adhering at all times to your fund terms. Cross trades, very similar to a secondary, and this actually happens, I think you probably know, more often than not, or more often than we like to think. So here, you've got Fund 3, it's got undrawn capital commitments. Fund 2 is running out of its cycle, and effectively Fund 3 buys the assets of Fund 2. And again, one's just got to be really, really careful here of conflicts and related party rules. The way you mitigate with that is making sure you're getting independent valuations. And so at all times you're acting in good faith and at arm's length. But that's another option. Then an American phenomenon is what they call strip sales. So here, managers strip out part of their portfolio, they put it into a new acquisition vehicle, which is funded by a new investor, so unrelated to the existing investors. And the strip sale is treated effectively as a disposal by the fund. The fund itself keeps a remaining interest in the existing portfolio, but the risk is for the fund original investors is that they can be diluted. And as the secondary buyer effectively puts more money into that asset. So, so where would you use things like that? Well, let's say you've end of investment period, you don't have the right to make follow-on investments, so you can't do any more drawdowns, or you're fully drawn down, and you need cash for these portfolio assets. So how do you do that? You flog a percentage of those assets off into this new vehicle, and then the new investor effectively puts cash into that new vehicle, recapitalizes the portfolio companies, but obviously in return for that, he's going to dilute your interests because you're not matching him pro rata on those on those rights issues as it goes down the line. Another American phenomenon, which I thought was really interesting and something that we could well make use of in South Africa, is what's known as an annex fund. Certainly I haven't come across one of these in South Africa, but certainly it is something well known overseas. And really what that is it's a specific dedicated fund that provides for follow-on investment. So, I said in the early example, the strip fund or strip sale, that you'd have this third party who would effectively be doing the injection of capital. Here would be your existing shareholder, your existing investors. So you would create a separate fund. So follow-ons are no longer permitted in terms of the current fund, or your current fund, they are permitted, but you've simply fully drawn down. You create a specific fund with your current investors and possibly even a third-party investor in that as part of the mix of investors in this annex fund. And that annex fund will then put in cash directly into the portfolio companies and getting their balance sheets right. And typically here, you wouldn't charge management fees on your annex fund. It would have a different waterfall. So it's not necessarily the worst thing. Certainly if you've got a good relationship with your investors and you say to them, listen guys, if we don't step in and do something, plug the gap here in the short term, we could have companies within our portfolio that can fall over. This is a way of plugging that gap, and this certainly was something that was done with quite a lot of success during the GFC. Right, Malani, I think we can move on to general, and I'm going to go through this relatively quickly because I see we have 33 minutes already. again, these are very similar themes of what we've been discussing already. You know, investor relationships, so critical. Just again, you know, keep in contact. Make sure you're on top of your reporting requirements. Don't miss any reporting dates. And if you think you're going to, because of, you know, extraordinary reasons, like we have, just simply can't get hold of information in order to provide the valuation reports, you know, again, proactive. Your investors, I'm certain in the short term, will forgive you if you've been proactive and communicate with them. They're just not going to forgive you if you ignore them right now. You know, they're also anxious about their money. I've spoken about business continuity, board meetings. I've spoken about, you know, making sure that you can do those online. Your employees, I think we all know, employees are the backbone of everyone's business. You know, make sure they can also work remotely. It is something also important, sort of related to employees, but it's a really critical thing if you've got a fund, an African fund, or where you've got to worry about, from a tax perspective, where decisions and control is vested. So, you know, that's very challenging in the current circumstances. So you often would have a fund set up in Mauritius, and you've got assets sitting in Nigeria, and, you know, you make sure your board meetings are Mauritius, and people fly out and they have those board meetings in Mauritius, or if they've got Nigerian assets, you know, they'll fly out to Lagos and they'll sit and have a board meeting in Lagos in order to ensure that they fall within, you know, the South African tax regime. You know, be alive to that, because you're going to need to conduct these kind of meetings. And if you've been doing it all by flying in and out previously, you know, that might not be possible right now or for a while. So give consideration to that, because you might unwittingly create a tax problem for yourself, where you effectively bring your entire fund onshore from a tax perspective. So, you know, be alive to that. Data privacy, make sure we're all working remotely, make sure you've got the systems in place that, you know, prevent hacking and loss of information. I'm going to briefly touch on force majeure. Force majeure doesn't really exist, or you certainly won't see those clauses. I haven't seen them in the fund document, but you absolutely would see them at portfolio company level. They'll be in your supply contracts, they could well be in your lease agreements. And what is, briefly, I'll spend sort of a couple of minutes explaining what is a force majeure. So a force majeure, it's a contractual provision, so it's not something that's in our common law. There's no sort of common law right to claim force majeure. But effectively, if you've got a provision that's built into your contract, that it typically suspends the rights between the parties. So I can't perform on this contract because of something completely outside of my control. Now, one will need to look at the wording very carefully of the clause itself as to what constitutes a force majeure or not. So there isn't case law up that says a force majeure by definition will include a pandemic. It may well not. It may be very specific things. It may be riots and strikes and war, and that's it. Well, is a pandemic a riot or strike or war? No, it's not. Could it give rise to those? Possibly, but right now, no. So one needs to look at it very carefully. Force majeure clauses also don't always work in one direction. They often have notice provisions attached to them, so you can't just simply claim it. So you know, that's something I definitely would take account of. But I'm sure you're going to have questions about that, and I've seen a couple of questions already popping up, and Melanie will take those through those at the end of the discussion, which we are getting close to. So the last really comment I wanted to make was under regulatory considerations. None of this stops your regulatory compliance. So as a general rule, whatever you had to do prior to the lockdown, you've still got to do it. So work on that default basis. There are certain exemptions, and I said this earlier, FECA are being proactive. They have issued certain exemptions. They issued a notice. In fact, 2 days ago, it's phase notice 17 of 2020. I've put the reference in the notes, which Melanie will be sharing with you, and that was issued on the 31st of March. And that effectively gives you an extension of period to comply with fit and proper requirements. In particular, it reduces the number of continuous professional CPD hours. It also extends the period in which you need to comply with your 2020 CPD cycle to 31st of August. And there's certain other exemptions that the notice deals with. And I'm sure we're going to see more of these. And I'll certainly be issuing alerts. And so if you want to keep updated with those, you just send me your email and I'll make sure you're included on my alerts to date. That about wraps it up. I think inclusion, this is a humanitarian crisis I think we're facing here on a scale, as I said, that I don't think any of us have seen in our lives. And I think it's a time for managers to sort of double down on their commitment to environmental, social and governance related investing, and evaluate their actions through a lens of social citizenship. I think we're all in this together. I think Melanie and I were discussing yesterday that there is goodwill in the market right now. I think it will last for a while, and I think we both agree it won't last forever. And as advisors, we're here to help, and we're in it with you. And to the extent we can, we are available and would be delighted to assist in any way. But I'll hand back to you, Melanie.
Thank you very much, John, and thanks for that overview. Much appreciated. The good news is everybody is still with us, and there are a couple of interesting questions coming through. So the first one I've got here is from Torba, and Torba would like for you to talk to us about whether earn-out clauses will be affected, given COVID-19 is a black swan and no one would have planned for it at the time of structuring transactions.
A lot of these questions are going to come up, and I'm afraid it's so difficult to give you a precise answer, because the answer is going to be it depends. I'm afraid it really depends on what the wording is. I think you're absolutely correct in describing it as a black swan. I don't think anyone foresaw this. Certainly not on the scale of what we've seen, where from a supply and demand side, we're literally shutting down the world economy. Certainly, I think earn-out clauses are interesting because they certainly are regarded as one of the ways, funny enough, to deal with this crisis. So it's not answering your question, but you may well see the re-emergence of earn-outs going forward, because that is a way of getting your price. I mean, it's not something PE likes. We don't particularly like earn-outs, but we may well be back in the realm of earn-outs if all else fails, where you're forced to do a sale.
Thanks, John. We've got a question from Kabelo. Kabelo, I'm going to allow you to talk. I see that your hand is up. I'm trying to get my cursor to work. There we go. Talking is now permitted. Please go for it, Kabelo.
Hey, how's it, John? How are you guys doing? I'll be brief.
How are you?
Very well, thanks, under the circumstances. You look like you're working from the office, but I won't go into detail there.
I won't stand up.
I just wanted to get some insight from you in terms of if one is in the process of going through advanced due diligences with investors, what sort of mitigants or things do you think we should be negotiating into the LPA and fund agreements? You had mentioned, the FM provisions and force majeure, and it's typically not something you'd ordinarily see in an LPA. Are those the sort of things that we should start to be considering?
So I don't think, I think it's going to more come from the LP side. You're going to see some of this than from the manager side. So you may well have managers saying, if an event like this happens, I want to be able to put a brake on drawdowns. So, kind of a force majeure provision that kicks in on a capital call. So you effectively prevent it from making capital calls. But there might be something that you also want at a manager side if you wanted to kick the can down the road. But I think for most managers, they probably wouldn't like that, because when you've got a deal in front of you and you want to act, you're potentially going to lose that deal. So I think it's potentially a dangerous provision to put in your LPA. I think we're going to have to think about very carefully what we should be putting in our LPAs. I mean, I think the fortunate thing for you is you're at that advanced stage, but you haven't actually put pen to paper. And we've got time to work through these issues and put in, requisite protections to deal with it.
Okay. So I think, and I'm just curious in terms of your comments regarding things like the inclusion of like a business continuity management plan or some sort of a disaster recovery type plan as mitigants, whilst, as during the fundraise period, you are obviously going through a due diligence. I imagine there's going to be a lot more focus in terms of, are you able to operate
100%.
under these sort of circumstances? And if so, what sort of provisions should you be thinking about in your BCM plans?
So I think it'd be the kinds of things that you'd be wanting to tell your investors that, your administrators have got proper disaster recovery and they can operate, they can function. Getting assurances. So when you go see your LPs, they say, well, how do we know you're going to be able to give your valuation reports when you need to give your valuation reports? If you've got a Pan-African fund, to the extent you've got a Pan-African fund, do you have people on the ground in the jurisdictions, or are you just going to fly people out? Because if you don't have people on the ground and there are no flights, you've got an issue. So again, it's going to really depend on the nature of the fund. And what you are targeting and what sector you're in. So, again, I think you absolutely should be saying to LPs, this is what I'm going to be doing as far as risk mitigation, business continuity, et cetera, but it's going to be very deal specific and fund specific. So I've given you a couple examples, Pan-African Fund, I've got people in Nigeria, I've got people in Kenya, I've got people in Mauritius. And they're able to operate remotely. So that is part of my business continuity strategy. And you can give that assurance. And if you don't, well, employ people there or make a plan. Because you're not going to simply say, well, we'll wait till the flights come back. And that's not going to be an answer.
I appreciate it. Thank you. Very insightful.
Thanks, Kabelo. I've got a question in the Q&A box. I finally figured out how to access it during a webinar. So Dowdy, you've got a question and I'm going to ask John to answer it live. And John, really the question is, what protection does a GP have with respect to a disbursement for a potential acquisition as a function of the lockdown?
So, in other words, I'm assuming you've signed your acquisition agreements at this point, your CPs are fulfilled, so you're effectively just now, it's payments and transferring shares. I'm assuming you're at that stage of the transaction and you're now looking at it and you're going, I'm paying way too much for this deal. Short of defaulting and, you are kind of, you are stuck. Again, this is very difficult to answer this type of question without looking at the specific terms of the sale agreement. So some sale agreements have got MAC type clauses in them as a CP. I certainly never liked them, but I've certainly come across them. Where they say, if there's a material adverse change between signing and closing, that is a CP event. And you could possibly rely on that to pull out of the deal if you haven't actually closed and dispersed. So I'm assuming when you use the word dispersed that you've kind of got to that point in time. But I absolutely would take legal advice on this. Otherwise, you're just waiting for a lawsuit to happen.
Thanks for that, John. Dowdy's confirmed that you were correct in your assumptions. I'm looking for more questions. I'm not seeing any right now. So please, if you've got any, please put them in the chat box or put up your hand or put them in the Q&A box so John can get to them. I have a couple of themes that I've just jotted down that's come through in your presentation, John. And really it is around, the three big ones was, one, be very careful about how you managing your funds going forward if they are cross-border and what that might mean for you from a tax perspective. I don't know if you've got any good suggestions or ideas for us that we should be following there. The second theme was really this theme about thinking differently around how we can address COVID-19, and it came up on your slide with the alternative mechanisms that you were putting forward from a US and a UK experience perspective, and perhaps just giving us a sense of which one of those alternatives that you put down there might work in the South African market, where we already would be best positioned to execute on it within our existing regulatory framework. And then lastly, and it's a really strong theme that came through, it's talk to your LPs. Don't sit and wait, but really talk to your LPs. Take the opportunity now to talk to your LPs. And this is really important because a lot of the guys, I think, on this webinar are going to be on our webinar with our panel of LPs, where they're going to have opportunities to ask questions. So following on from this talk to your LP theme, what are some of the things that GPs should definitively be talking to their LPs about? So now those are three big ones. I'm throwing them out there. All yours.
Sure. So I mean, I think you said everything correctly on the communication front. I think that's absolutely spot on. And I said that up front. This was going to be a theme of my discussion. I mean, the only further points I'd add to it is it's that balancing act. I mean, as much as you should be communicating with LPs, as much as you should be sharing and being proactive and business continuity and checking your documents and your finance agreements and engage. From a manager perspective, you still run the fund and you still expect to run the fund. The LPs don't run the funds. They shouldn't. In fact, the limited liability can be compromised if they did. So it's not a case of handing over responsibility to and asking the LPs to do the decision making here. That's not what I'm suggesting at all. It's still the manager who manages the fund. The GP is in charge of the fund. My point is simply focused on the communicating, open, transparent, no conflicts of interest, or if there are, disclose them, and do everything by the book and just engage. Your second, so I'm going forwards to backwards here, backwards to forwards. So you asked about the tax issue and how you mitigate that risk. That's going to be a challenging one if you don't have people on the ground. And I would strongly recommend you got tax advice on it. So, Mark Lennington at our office is one of the top private equity tax lawyers in the country. And you'd be wanting to speak to someone like Mark. I'm happy to share his details. But that is absolutely fundamental, that you're on top of that, because you can very easily trip over your shoelaces in that regard. I'm not a tax lawyer, so I'm not going to presume to give you further advice than that. But other than speak to the tax lawyers, it's just a red flag that I've raised. On your second point is, of those options, which is the preferred one in the South African context? I think it depends. I think it really does depend. I think the important thing, it's going to depend on the size of the fund. It's going to depend on the timing. How quickly do you need this extension? Is it something we need to do today? Is it something, that can wait? It's a potential issue I could see down the line in a year from now. What's my LP's appetite going to be? What are third parties' appetites going to be? You could be in a sector that's completely unaffected by COVID-19. I'm surprised if there are too many sectors, but there are some that are actually doing very well in these challenging circumstances. So it could be that you're not as affected as others. So it really does depend. I think the real message that I'd like to get out now is rather start thinking about that now, not if you've got 2 years left in your fund. I've still got 2 years. At the very least, you should be having a conversation around it right now. We don't know how long this is going to last. I really can't see a lockdown continuing for months and months on end. I think the world economy will be bankrupt. Certainly will be in South Africa. But there are going to be issues. This is going to last for a while, and the impacts of COVID are going to last for a while. So that certainly would be something that I would be thinking about right now. Is it, and it's in all stages of the fund. It's not just at the end stage. It's in the investment stage. It's also in that capital raise stage, because it's all very well saying, well, we'll agree with our investors to extend the final close date. That might seem like a very simple amendment, but it can have interesting knock-on effects as far as your equalization provisions are concerned. That could be completely, inappropriate to use the kind of equalization provision that you're currently doing if your final close was 3 years after your first close. So it really does depend.
Thanks, John. We have a question from Mamecha asking if capital is being raised and there is a pipeline of deals, clearly there's going to be a valuation issue. And how would LPs look at this? Have you got any view on that?
I don't, to be honest. It's not my area of expertise, so I'm not going to presume. I'm more a fund specialist lawyer, so I wouldn't like to hazard a guess in that regard. I think this is something your corporate finance people should be looking at. But yeah, you could probably safely assume in a lot of cases that your current valuations are really problematic right now, or just they've got the assumptions are wrong. The assumptions looking forward are incorrect.
Absolutely. And we'll save that one for the LP panel when we get there. But Mamecha, I'll also, just to point you in the direction of the International Private Equity and Venture Capital Valuation Guidelines, that's IPEV, they issued special guidance for valuations as at 31 March, specifically to provide a framework for delivering LPs fair value information that they need, given the magnitude of the crisis and the significant uncertainty that this crisis has created. And I'll send them through. There's a question here from Rory. Rory, you always ask the hard ones, so John, be ready for it. And
well, I saw his question. He's wanting me to know write his talk for next week.
So Rory, it's a good thing you don't have equal rights here to speak, and I'm speaking on your behalf, because otherwise that would be the rest of this conversation. But Rory's question is a really good one, and it is around the big areas of emphasis. What are they going to be in LPAs that are concluded post-COVID-19 or in the post-COVID-19 world?
Yeah, it's a bit of stargazing here, Rory, so it's going to be quite tricky to say, because I think we really are in the early stages here. So it really is a bit of guesswork and crystal ball gazing here. I mean, I think I've already mentioned one. I wouldn't be surprised if you start seeing LPs saying, or even managers, depending, wanting some sort of break on capital calls and extensions of funds. But you could think there are a lot of knock-on implications of that. You know, if you put a break on it, does that mean that your investment period automatically gets kicked out during this, let's call it force majeure event, this extraordinary event? And now the manager, does it continue to earn fees on capital commitments as opposed to invested capital? So you could see our managers would be inclined to call a force majeure because they just sit back. If they aren't invested, it gives them a whole lot more time to make investments. Similarly, or conversely, that kind of clause, managers wouldn't like it because, as I said earlier, they want to move on a deal. And they think there's a good opportunity to get an acquisition for a steal. Then they don't want their LPs calling force majeure or some sort of suspension event. But that was certainly something that I thought about, and I asked one of my former colleagues who heads up a private equity team for a large US crowd. And I said, have you seen these kind of suspensions? He said, not as yet, but there's talk about it. So if they start, you know, we typically follow where they go. So that certainly is something that they are talking about. You know, other things to look out for, you know, I think you're going to see a lot more around, certainly if there are failures. So it really depends. I think to answer your question, what will we see be concluded in our LPAs will be very much dependent on what actually happens here. You know, if we come out in 2 weeks' time out of lockdown and somehow we, by some miracle, have managed to contain things in South Africa, and we kind of go back pretty quickly to business as usual, then I'm not expecting to see a great deal. But if we see really, you know, the market getting trashed for a sustained period of time, you know, then, you know, your guess really is as good as mine as to what we're going to see. But our reporting, I mean, that's going to be, if the report, we've already seen that trend, Rory, as you're aware, of increased reporting requirements. That would be one that I'd be prepared to bet the house on, so to speak, is that you're going to see a lot more emphasis on reporting requirements from an LP perspective. I mean, that will one, I think you could safely say will happen. And wanting to know things like what business continuity strategy do you have? You know, wanting to know a lot more detail than currently is the case.
Thanks, John. If there are any more questions, please put them in the chat box or put up your hand and we'll get to you. There was another one that was sent through in advance, and it's another crystal, I guess more crystal ball gazing, but quite relevant. To a large extent, our PE industry has followed the international PE markets. The question really is, do you foresee the impact being different in the South African private equity market? And if so, how so, from what we've seen in the international markets?
So I think it will, to that extent, I actually think, you know, we're all, as I said previously, in the same boat. So I would expect us to follow the lead of Europe and the US primarily. And so if we see changes, and so the kinds of things that I've mentioned under, you know, how you kick the can down the road with annex funds and strip sales, I mean, you'll probably see a lot more of that in the local market than you saw previously. You know, if one goes back to the GFC up, I mean, if one looks at the sort of how advanced the local PE market has come from those sort of GFC days to where it is now, you know, we're much more sophisticated than we were back then. You know, there were very few, you know, the market was a fraction of the size it is now. and it's got a lot more advanced and sophisticated. So, you know, would I be surprised seeing annex funds? No, not at all. You know, would I be surprised seeing strip sales? No. I think you're going to see a lot of innovation that's going to take place because we have to evolve to survive.
So I think that lets you off the hook, John.
Excellent.
I think we've answered all the questions. I think all that's left to say is thank you very much for joining us today. Thank you for having the conversation. It is very useful from a timing perspective, given that we will have our LP panel discussion next week, and hopefully this conversation has prepped us all well in knowing what we should be asking from that LP panel discussion next week. We will be sending a link to the recording and the presentation together with John's detailed notes out to all that attended today. Thank you again for joining, and we look forward to seeing you at our next webinar on Tuesday morning at 9 a.m.